Yes, ma'am.
Do you allow for bathroom breaks, or how does that work, and how long do these sessions go on, you know?
We try to be reasonable and do, yeah, I mean, they'll take breaks. How long do they go on? Generally, they'll start at 8, 9 in the morning. It could go to 5, 6. Sometimes we'll work through the evening. Of course, we work on weekends. If it's a large record examination, it could take a number of days to get resolved. But, you know, we try to be reasonable and take washroom breaks and rest breaks and lunch breaks. And I forgot to repeat the question, so I'm sorry. Yes, sir?
So would the candidates be informed about how many computer stations he will be assigned to, so he could bring in the number of appropriate watchers?
Yes, the question is, will the candidate be told in advance as to the number of stations that will be used to do the records examination, so they know how many people to bring in? And the answer is yes. They will be told at the very beginning how many stations there are. If at some point they change the number of stations, they may want to add more stations or take stations away. They will only do that either in consultation with the parties. If they talk to the candidate and the objector say, you know what, we'd like to add a couple more stations. Do you have enough people to do that? And if they say yes, they'll add more stations. If they say no, they won't add more stations, but they may do it the next day. And they'll tell you at the end of the day, we're going to start again tomorrow at 9 o'clock. We're going to work this many stations. And then you are expected to have as many people as you need to cover that. So they will try to give you advance notice in either case.
Okay. Does the watcher needs to be an attorney?
No. The question is, does a watcher at a record examination have to be an attorney? And the answer is no. The question was, if during the course of the record examination, is it possible for either side to offer up information as to a particular voter, saying, oh, I know that John Doe lives at such and such an address, or maybe you should check this address, and other information that may be pertinent to it. We don't expect that the watchers sit there completely still, and we don't put muzzles on anyone. So if they have information that's pertinent, sure, they can offer that up. And there will be this, discussion. You put 3 human beings at a computer station all day, and they're going to start talking about something. And, they may be talking about John Doe living at this address or that address. It's okay to offer up that information, right? But what we want to make the point is that if I'm a candidate and I strongly disagree with a decision that the clerk just made as far as the signature is concerned, you can say quietly, politely, you know what, I don't agree with that, and I want to appeal it. What we want to avoid is someone trying to coach the board employee as to, well, look at how that T is crossed or that I is dotted. That's definitely a signature made by this person. Those are kind of discussions that we're really not trying to encourage. The board employee is supposed to make a decision based on his determination and not the judgment of the candidate or of the objector or the representatives. They're not there to record their opinions. The employee is there to record the result of his or her best judgment. He can listen to the discussion in a polite atmosphere, but at the end of the day, it's going to be the clerk's decision. Yes, sir? The first question was, how many computers do we have in a room, and how many people are generally assigned to those computers in the room? And the answer is, it depends, because we've got a public viewing room upstairs on the 6th floor, and some of you may have been up there, and I'm not sure how many computers we have up there. I'm gonna guess around 50 or 60. And it gets pretty tight up there. It can get kind of close quarters, so that's another reason why we're limiting the parties to 1 watcher per station. because it can get pretty crowded and sometimes uncomfortable up there. But we're also spreading out. Wherever there's space, we're going to be using the conference room up in the 8th floor. We're going to be using this area down here. So we're going to be spread out in different locations. We'll try to make it, as comfortable as we can, but I can't guarantee anything. As far as the number of people, again, we have one watcher per station. We will notify you in advance how many stations are going to be assigned to work that particular records examination. So you will know in advance how many people you will need to cover that records examination. The question is, are the board's clerks or examiners given any training or advice on how to make a signature comparison? As I mentioned, we have a forensic handwriting expert that we retain for this purpose, for the electoral board purpose. He does from time to time give training to the employees, and many of them have done this before. And so, through experience, through training, they get pretty good at making comparisons. But again, we have the backup. Every one of those that's appealed is going to go and be reviewed by the handwriting expert, and then he will make the call. Oh, and that goes back, I think, to the second question that Ellen had, and that was, you're going to get a report, bless you, you're going to get a report at the end, and is that going to have the results of Mr. Hayes, who's the handwriting expert? And the answer is yes. That will be on the same report. It won't be given to you until he's reviewed it, or if it is given to you before he's reviewed it, you'll be given another report after he's reviewed it. Okay? And the other important thing, too, is that you're not going to get a report until the records examination is done. So if you've got a record exam that's going on several days, please take careful notes. You need to keep your own notes, because we're not going to be providing you with any record of what our calls are until the very end. So take copious notes as to what is done, what is said, and what is decided at the records examination. He had his hand up first. Yes, sir. The question is, if there are 10 objections to a single candidate's nomination papers, would that candidate have to entertain or defend against all 10 objections? And the answer is yes. Yes. But as to certain, if there's common issues of fact or law, some of those things can be heard and decided at the same time. They will be consolidated for hearing on those particular issues where there's commonality. But otherwise, the candidate is going to have to defend against all of his objectors. It may not sound fair, but each objector is entitled to a decision as to their individual objections.
So who would make that decision as far as actually consolidating or not consolidating?
The question is, who makes the decision as to what items are to be consolidated or not? And the answer is the hearing examiner, the hearing officer. He makes that decision. Okay, I'd like to move on. The appeal, I know I touched on this before, but I want to emphasize it again. To preserve the appeal, the watcher must immediately inform the record examiner of the appeal at the time such finding is made. If you do not do so, the party shall not be allowed to present any evidence or argument of any kind with respect to the record examination's finding or the issue to which it relates. In any future appeal or reconsideration of the record examination finding is waived. That's important. Please make sure, if you want to preserve the appeal, you want to preserve the issue for appeal, make a timely objection to the record examiner. The record examination results, I mentioned to you that at the end we're going to give you a printout, a report that'll have in summary form and in detail form the results of all of the objections that were made and the decisions as to each objection, whether it's sustained or overruled, and whether or not the candidate or the objector appeal that decision, and any finding that the board's handwriting expert makes with respect to a genuineness of signature issue. As far as records are concerned, generally we transmit to the hearing officer a report. There's a separate report that's pretty much the same as the petition filing detail report. That's the end of your PowerPoint presentation. But it also contains, for example, if it's a signature issue, it'll contain a copy of the voter's signature. So the hearing examiner will have that in his or her file, the Electoral Board file. We do not release copies of records that contain voters' signatures, with very certain limited exceptions, which I will get into. But generally, we don't allow copies of signatures outside of the board. You can, however, ask for a copy of a signature in the board's voter registration database. If, for example, you want to present a copy of that, you've retained a handwriting expert, and you want the handwriting expert to review those documents in preparation for trial. We will make copies of those records available to a party if it's ordered by the hearing officer or the Electoral Board, that the copies are absolutely necessary to the party's case, that you execute a non-disclosure agreement, and the non-disclosure agreement essentially requires you to promise that you will maintain control over that record, and you will not allow that record to get into hands of unauthorized persons. So you are responsible for that record. And if it gets out, you're going to be the one that's going to be responsible for any consequences. You know, we all live in the world of identity theft, and things can happen. So we want to make sure that these kinds of records do not get into the wrong hands. So any party wanting this signature has to execute a non-disclosure agreement. And finally, they're going to pay $10 10 cents per page fee for reproducing that. Okay. Evidentiary hearing. If at the end of the records examination or at some point that there are issues which require the hearing officer or the board to hear evidence, they will conduct an evidentiary hearing under Rule 8 of the board's rules of procedure. It's important that there be a timely request for that. And an evidentiary hearing will not be conducted unless it is timely requested. And the rules are very specific as to when you may request and file a motion for an evidentiary hearing. If it's a records examination issue, you have until 5 p.m. of the next business day following the day in which you were notified and given the results of the records examination. If it's not related to a records examination, then you have to file it by such date as may be set by the hearing officer. And the hearing officer, one of their duties is to schedule things out, and one of their scheduling items is going to be a date certain for requesting an evidentiary hearing. You must meet that date. If you do not meet that date, or if you do not meet the date set for appealing records examination, your appeal is deemed waived. Again, expedited process, an expedited process. We have to move this along.